An August 25th ruling in the Fort Worth Division of the Northern Texas Federal District Court reveals the fact that Texas state leftists had attempted to infringe on the in-public gun carry rights of adults under the age of 21. And the decision could be a harbinger for other cases of infringement in other states. Hi everyone, I'm Gardner Goldsmith for MRC-TV. And here's the story. Kayleen Deese writes for the Washington Examiner that the state of Texas ban on gun carry imposed on adults under 21 was shot down, but will be allowed to stand for 30 days when the state's appeal is heard in the 5th Federal Circuit Court. Quote, U.S. District Judge Mark Pittman, an appointee of former President Donald Trump, found that the Second Amendment, as informed by founding-era history and tradition, did not exclude 18 to 20-year-olds from the right to bear arms. Pittman ordered the injunction stayed for 30 days pending appeal, meaning it won't immediately go into effect, according to court records. Well, given the June U.S. Supreme Court ruling in the New York State Rifle and Pistol Association v. Bruen case, that one affirming the right to carry in New York without obtaining a permit from the government for proper cause, it comes as no surprise to many observers that Judge Pittman should come to this conclusion. Writes Deese, quote, the High Court's decision in New York State Rifle and Pistol Association v. Bruen also ordered the federal judiciary to apply a history-only test when considering legal challenges to gun regulations. The new standard holds that regulations on the Second Amendment are constitutional only if it, was similar to those around in the 18th century when it was ratified. Which means no restrictions. Here, Deese's use of the term regulation when he means government restriction buys into leftist contemporary language misuse and is wildly incongruous with the founders' meaning of the word regulated, which meant well-trained and regularly practiced, and recognized the inherent natural right of humans to defend themselves without infringement, just as the Second Amendment actually says. The suit against the government of Texas was brought last year by the Firearms Policy Coalition, FPC, which has similar cases pending in California and Pennsylvania. And it was brought on behalf of 2 adult plaintiffs who were under 21. Notes Deese, quote, Cody Wisniewski, an attorney for FPC, told several news outlets in a statement that the ruling marks a significant victory for the rights of young adults in Texas and demonstrates for the rest of the nation that similar bans cannot withstand constitutional challenges grounded in history. And even CNN quotes Wisniewski after the victory. Quote, Texas cannot point to a single founding-era law that prohibited 18 to 20-year-olds from carrying a functional firearm for self-defense because not only did no such law exist, but those individuals are an important reason why we have a Bill of Rights in the first place, said the coalition's senior attorney for constitutional litigation, Cody J. Wisniewski. And young people have just as much a right to keep and bear arms in public as adults over the age of 21. The fundamental right to keep and bear arms for self-defense against any aggressor, be it a thug, a gang, or a gang calling itself government, is universal and is supposed to be untouchable by any political agency or agent. People of the founding era understood that. Perhaps with rulings such as this one, more contemporary Americans will take the time to learn about the moral core of human rights and see how statutes like those infringing on the right to keep and bear arms are really incredibly towering insults to their neighbors now and to those who sacrificed so much to be free throughout history. Practically speaking, the criminally minded don't pay attention to so-called gun prohibitions and license requirements at all. So, The key here is the absolutely essential moral part of this story. It's the morality of not infringing on the rights of one's neighbor. Even if a judge had ruled that it would be okay for the government to prohibit public gun carry for adults under the age of 21, or even if the Constitution said it was okay, such a political move would not be okay. It would be immoral. Period. Thank you so much for watching, everybody. Please like and subscribe if you're watching on YouTube, and do the same. Hit the little plus button over on Rumble where they don't censor us. Please double check on YouTube to make sure that you are subscribed if you thought you were already subscribed, because people drop off all the time. We'll see you at MRCTV.org, and we hope you'll visit the MRC Store when you stop by MRCTV.org. And you can help the Media Research Center on its 35th year. And also, if you get the opportunity, visit us on Twitter. There's always a lot happening on Twitter. New things, a lot of things happening on Twitter that you'll see. And you can visit us on TikTok and Instagram, and also in the Facebook page. A lot of great interaction there. You can find me on Gab as @GardnerGoldsmith, and on Twitter I'm @GuardGoldsmith. So thanks so much for being in touch. Really appreciate it. For MRC TV, I'm Gardner Goldsmith.